Hey everybody, my name is Mauricio Raul, founder and CEO of Premier Law Group, and thank you so much for joining us today. I wanted to give a real special shout out for David Lindahl, obviously, for inviting me today, and also Jeannie Olofsky, who's been very kind to me over the years. So thank you for having me, very humbled. I'm not going to spend too much time on my background. I'm sure we'll have a little bio there, but I want to let you guys know I am the founder and CEO of Premier Law Group, and 100% of my practice is syndication law. So what we're about to talk about today is all I do day and night, and sometimes late into the night. But Dave had asked me to kind of talk to you guys a little bit about the updates of the securities laws, since there have been quite a few over the years. And so that's my plan. I'm going to start with a little bit of the basic and the foundation so that when we get to the updates, it'll make sense. But that's kind of my goal here today. So let's start with one thing that I think a lot of people make mistakes on is, are you really needing to do a syndication? Are you needing to go through all that trouble of the compliance laws? And so what I like to kind of illustrate is that there's kind of a world of securities laws, and obviously it'd be nice for us to be out here, because if we weren't really issuing a security, didn't have to comply with the securities laws, then we wouldn't have to worry about all the compliance and the security stuff. A lot of times we can structure syndications where we kind of eliminate the securities standpoint, but it's very difficult. And so what you really need to ask yourself is, are you dealing with the security? And a lot of people think of securities as stocks, bonds, mutual funds, maybe promissory notes, but the reality is the SEC defines a security very broadly. And so it includes other things like TIC agreements. I see a lot of people who think, hey, let me structure this so people own the property directly, and therefore I get around the securities laws. Not true. Maybe they do a profit sharing agreement or a side deal. And none of that really matters. You can do an LLC, a corporation, TIC agreement, profit sharing agreement, handshake, high five, doesn't matter. The structure is irrelevant. What you need to think about is, anytime you take money from investors where the return on that money is generated by your efforts, that is a security. In other words, if your investors are passive, they're just giving you money, and they then go home and sit on their couch, and you're doing all the work, you are dealing with a security, whether you have any documentation or whatever structure you do. So that's a very important point, and a lot of people, I think that's kind of one of the big mistakes, is they structure it in such a way and they think that they can get away from the securities laws, which is not true. And so what you need to realize that once you are dealing with a security, which is going to be in most of your cases, all of you, there's only three things that we really need to worry about. Number one is we need to register that syndication or that security with the SEC, or we need to find an exemption to registration, or number three, it is illegal. That simple. If you're doing a security, you need to register the security, find an exemption, or it's illegal. Now, I'm going to assume most of you are not going to be doing an illegal offering, although illegal offerings don't just mean Bernie Madoff stuff, right? It doesn't just mean fraud, intentional misrepresentation, you're trying to swindle your investors. I assume none of you out there are thinking of doing that. But it does also include smaller things like failure to disclose all the information, failure to provide full documentations like a private placement memorandum if it's required because you have non-accredited investors, which we'll talk about in a second. So illegal goes a little bit beyond just fraud, but obviously we're going to try and get around and make sure we don't do anything illegal. You really don't want to do a full-blown registration either, and the reason for that is that registration is going to take you probably a year or two to get through the SEC and probably cost you 6 to 7 figures to go through that process. Now, if you're in contract to buy a building or a property, how many of you out there have a year or 2 years to wait until the SEC approves your deal before raising money? It's just not feasible. So what I do, and what we usually try and do, is we try and find an exemption to registration. And look, that's exactly what I do. That's the world that I live in. And the good news is that there's a couple of exemptions that apply pretty much to everyone, and they're the most popular exemptions. And I'm going to go through both. Well, let me go through one of them first, and then explain why it's such a popular deal. I think the last time I saw some SEC guidelines or figures, about 90 or 92% of all offerings rely on these Reg D exemptions, and you've probably heard what a Reg D looks like. So let me start with the original the original Reg D, these are Reg Ds, I don't want to get too, too complicated or any technical, but there's this is as technical as it's going to get. There's an exemption called 506B, which you may have heard of. And back in the day, it used to just be called 506, but now they added another exemption, which we'll talk about next, and they then called this a 506B. And the nice thing about 506B, and the reason it's so popular, is number one, you can raise an unlimited amount of money. That's pretty nice. So even the big boys, even the Goldman Sachs of the world, the Merrill Lynches of the world, they raise billions of dollars under this Reg D exemption, 506B, because they have that ability to raise an unlimited amount of money. So that's the good news. You also are allowed to take up to 35 non-accredited investors, which is really good for someone who's just starting out. Now, just as a reminder, just make sure nobody's left behind, an accredited investor is someone who either has $1 million in net worth, excluding their primary residence, or they're an individual who has made $200,000 the prior 2 years and has a reasonable expectation of earning $200,000 this year. And if you want to combine that with a spouse, that goes up to 300. So a lot of people who are starting, they go to their friends and their families, and inevitably some of them are non-accredited, which is okay, because under 506B, we can take up to 35 non-accredited investors, as long as they're sophisticated, but that's not really a big barrier that we worry about too much. The other reason, honestly, I think the main reason, well, there's two main reasons, but the main reason this is so popular is, number one, it preempts state law, which is just a fancy way of saying we basically don't have to worry about the state securities laws because we're relying on a federal exemption. And that's nice because in the old days, if you sold, let's say, into 8 different states, you had investors from 8 different states, well, then you would have to go and hire a local attorney in that state and hire all 8 of them, which is going to get pretty expensive, and you've got to worry about 8 different sets of rules, and it just becomes a nightmare. So when you have the preemption, it's a really nice advantage. Now the states, a lot of their power has been stripped because of this, but they still have jurisdiction over what's called the anti-fraud statute. So going back to the illegal part, if you're, Bernie Madoff or you're doing something illegal, they will jump on that. But in general, the states, I always joke that they're kind of bored and twiddling their thumbs, waiting for something to happen. We can talk about what an audit looks like because it's very interesting how they jump on some of these. The other reason it's so popular is because it is a safe harbor, which means if we comply with all of the enumerated conditions, then we are guaranteed that we have fulfilled the exemption requirement and we don't have to prove anything, we don't have to show any reasonableness or anything. It's a very clear-cut thing. Now, for those of you who do know 506B, you're saying, wait a minute, Mauricio, there's a couple things that you've left out, which is true. So the big drawback on a 506B is that there's no advertising or no solicitation, which means advertising is generally pretty obvious. You can't, talk about it on Facebook. You can't talk about it on a podcast or, an ad in the radio or, whatever. You can't do that. And you also can't solicit, which means you can't just go to these conferences that everybody goes to and start handing out your business plan. That would be illegal. So that's really the main restriction on 506B, which was one of the reasons one of the updates came along to kind of address that. And then the final thing is, there's 2 final things. One is really, it's the bad actor provision, which, won't get into too details, but essentially if you or one of your co-sponsors has engaged in one of these bad acts that are enumerated, there's about 11 of them, basically, convicted of, securities fraud or sanctioned by a state, then you may be either prohibited from doing the raise or you may have to disclose it. And then the last one's just a Form D. So at the end of this process, once you've raised all the money, you are required to file what's called a Form D with the SEC. It's just a notice filing. It doesn't require any approval. The SEC just uses it for information, like the statistics that I threw out, what percentage of people are using this exemption versus that. And that's filed with the SEC free of charge. And then we take a copy of that Form D and we file it with each individual state. That's the only real requirement on the states. We file a copy of the Form D, just let them know what we're doing. Hey, we just raised a couple $1 million and here are the non-accrediteds, what have you. And we file a copy of that with the states, and of course, depending on the state, they'll want their filing fees, their taxes, as I call them. So, but that's pretty much it. Unlimited amount of money. You can take up to 35 non-accredited. You cannot advertise, but it is a safe harbor. And I think the two reasons why 506B is so popular is because of the preemption. So it doesn't require you to go to each state and talk to attorneys. And also it's a safe harbor, so we comply with that. So that's the old 506B, or the old 506, which is now 506B. 90% of the Reg D, anyway, 90 to 93% of the Reg Ds are actually under 506B. So the next thing I'm going to show you, even though I was excited about it and it has a lot of promise, not for some reason, I think I know why, but for some reason not many people are going to this new exemption. So let's do the next one. This is one of the updates. This update happened in September of 2014, or actually, I'm sorry, 2013, and it was a result of a legislation, which is the Jobs Act. You may have heard that, the Jobs Act that passed under Obama. So that got passed in 2012, and then it took the SEC, as it usually does, about a year to get around to doing the regulations. So the next one, they basically created a new 506, but now they called it 506C, as in Charlie, or crowdfunding, sometimes people refer to it. So what happens in a 506C? Well, if I had a comparison chart next to each other, it would be easier. But number one, you can still raise an unlimited amount of money. So that's still good. Well, let's do a side-by-side comparison here. So on 506B, we could take up to 35 non-accredited investors. Well, under 506C, you can only take accredited investors only. Okay? Only accredited. And you must take what's called reasonable steps to verify that they are accredited. So under 506B, we basically send them a questionnaire. They check the box. They represent to us that they're accredited or non-accredited. That's good enough. Under 506C, you can't rely on a check the box. You actually have to go and take what's called reasonable steps to verify, which typically involve digging into their financials and digging into their assets and finding out, depending on what they're relying on, whether it's $1 million, then we've got to find out where the $1 million in assets are, property valuations, bank accounts, brokerage accounts. And if it's income, probably a W-2 or a 1099 or tax returns or what have you. That's kind of messy, and so there are a lot of third-party companies that'll do the verification for you, which I totally recommend because it's, in my mind, super inexpensive. It's like $80 or maybe $100 a head, depending on how many investors you have. So to me, you put that in your budget, $2,000 or $3,000 in your budget, you ship that out to a third-party verification company, and they will then come back and say, hey, we've done all the research, these guys are accredited, and you can rely on that. Another easy way to do a reasonable steps is to get a CPA verification letter. The theory is because the CPA is very familiar with your financials, they know what you make, they know what you own. So a CPA, third-party CPA verification letter works. You can also get one from an attorney and one from a broker-dealer, but the traditional one is a CPA. So maybe I'll adjust what I said earlier. Try and get as many to sign the CPA verification letter, which I've got a couple of templates because it's got to be pretty precise language, and I'm happy to send that to you. And then for those who don't have CPAs or the CPAs don't want to do anything or don't want to verify because there's some liability issues for them, then you would send them over to a third-party verification company to do that. The main benefit, I guess, from this exemption, which is why everybody was so excited about it, is you can advertise. So now you can take an ad out of the Super Bowl or go on podcasts or put it on your website or Facebook ads or just, there's really no limitation. There's really no gray areas. Can I do this? Can I do that? You have carte blanche, I don't know if that's a word, whatever that is, here to advertise. So that's the main benefit. And I really thought because of that, this would really open, I was saying this is going to open up your world. I think the challenge is the reasonable steps. I think most sophisticated investors, if you're going after big boys, big investors, they typically don't like to give their financials, and if they're looking at 6 different deals and you're the only one looking for financials, all else being equal, they'll probably go with a 506B. So I think that's the main reason why this hasn't gained too much traction, but it's a very attractive exemption. And of course, keeping down with our comparison, it also preempts state law. So preemption again, so that we don't have to worry about the states. Oops, preemption, and also it's a safe harbor. So again, if you comply with these, if you comply with these rules and regulations, then you are assured of having satisfied the SEC. The Form D, same thing. Form D, you file and you would just check the box that this is a 506C. That's all, by the way, a public record. So it goes on the SEC website. You can search. If you're investing in a deal, you may want to do a search on the company just to make sure they file their Form D. The Form D is due 15 days from the date of the sale, the first sale. So if it's a brand new one, maybe they haven't gotten to that 15 days yet, but that's what's required on the filing side. So I think that covers the 506C. And I'm sure you guys have a bunch of questions, so I'm looking forward to the live Q&A at the end of this. But that's essentially the difference between a 506B and a 506C. It essentially pivots on whether you want to do advertising or not, or whether you want to take non-accredited investors. Because if you want non-accredited, we're looking at 506B, and you're not going to be able to do a 506C. You guys still with me? The next one I want to talk about, which doesn't apply to everyone, so that's why I usually don't focus on it too much, but it maybe for some of you might work really nicely. And this is also a new exemption called Regulation A+. Now, I'm not even going to go into what Regulation A was, which has been around for a while because nobody used it, and it just had all these limitations, and it didn't preempt state law, so you had to go into every single state, and it's just not worth it, especially with a 506C. So I wouldn't even get into what Reg A was. But Reg A Plus came in afterwards, around the same time as 506C, and I'll give you let's do the good, the bad, the ugly, I guess. Let's do the good. So the good is you can't do an unlimited raise, but you can do up to 50 million, which I think for most of us, that's going to cover you. So that's not a huge deal. What's really attractive about a Reg A Plus is you can advertise, okay, just like a 506C, but you can also take non-accredited investors. That sounds fabulous, right? You can advertise, you can take non-accredited investors. This is looking really good. So why doesn't everybody use it? Well, first of all, it doesn't involve a full-blown registration, but it sometimes is referred to as a mini IPO. So you do have to go through the SEC and get that registered. And that process typically takes about 6 to 9 months. If you're really good, you might be able to get it in just under 6. But again, if you're doing a project-specific deal and you have 90 days to close, you don't have 6 months to wait around for the SEC. What happens is you submit your offering to the SEC, the lawyers look at it, they give you feedback, you fix it, you send it back to the SEC, they do more fixbacks, and guess what? You're dealing with the government. And we all know the government works really, really fast, right? So it just takes a while to come back and forth. But anytime you see people advertising and looking for small amounts of money and non-accredited investors, they're most likely doing either a Reg A Plus or it's an illegal offering. So that's kind of one of the takeaways, the negatives, the bad. The other bad is even though you can take non-accredited investors, you are limited to 10% of their income or net worth. So whatever the greatest one. So if you've got somebody who's got $100,000 income and $100,000 in net worth, the most you can take from them is $10,000. And obviously if they've got 500 grand in net worth, you can take $50,000. But there is some limitations to that, so you want to be aware of that. And then that's pretty much it. 10% income, that's kind of the negative. And then so the good, the bad, the ugly. The ugly part is the cost, right? So I would say if you're thinking about doing a Reg A Plus, cost-wise, you're looking at about $75,000 all in between legal fees, filing fees, and ongoing compliance, which is kind of the next ugly part. Which maybe ugly is not the right word because you just outsource this, but there's a lot of compliance involved. So once you do a Reg A, you're not quite a public company, but you are required to provide annual reports, which include audited financials. You're required to do semi-annual reports and also monthly reports. And then there's an exit report. So you got all these compliances. Probably the most expensive part, I think, of that is the audited financials, which will get more and more expensive as you go through because when you start, not really much activity going on, so the audited financials aren't going to take that long. But as you get into year 2, 3, or 4, or 5, as you guys know, audited financials are pretty big. So that's kind of the Reg A Plus. Again, it really only works for funds. Sorry, I should have said that at the beginning. If you're doing a project-specific, it doesn't work. But if you're thinking about doing a fund, where you're not really stressed for time and you can wait 6 months and then you've got all this time to bring in the money and then do the investments, then Reg A Plus is something to think about if you'd like to advertise and do and also get non-accredited investors. And then the big change between Reg A and Reg A Plus, and maybe I should, this is really the good, but I'll put it at the bottom, is it, again, preempts state law, preemption. So again, we don't have to worry about the states other than make sure we're not providing any fraud activities. So that's Reg A Plus. Let's do a couple more. The other one that came in later, I think it was 2015 because it took the SEC even longer, was what's called regulated crowdfunding. So this is the true crowdfunding. A lot of people call crowdfunding really was just 506C. They just happened to, advertise on their website, and everybody called that crowdfunding, which, whatever, it's a term. But the real crowdfunding is this called regulated crowdfunding, which in all honesty, I don't have any clients that use it. It appears to be pretty attractive, but then when you really dig into things, it's not. So let's talk about some of the limitations. What's the good news about the regulated crowdfunding? In theory, you could advertise and do non-accredited. The reality is you can advertise, but not a whole lot. So you can give kind of some simplified, big picture, hey, I'm raising $1 million to buy a 100-unit apartment complex in Texas, and your ROI is going to be, we anticipate ROI between 10 and 15%, whatever. Then you have to give them a link to a website, which is actually going to be a portal. And the portal has to be hosted, you can't send them to your website, it has to be a SEC broker licensed website portal or an SEC licensed portal specifically for this stuff. So you can talk a little bit about it, but then you just send them a link and you send it over there. So it does have some advertising, but not to me it's a little misleading. Number two, you're limited to $1 million raise per 12 months. So again, depending on your size, raise size, this may not apply. Obviously, if you're raising more than $1 million, this is not going to be around for you. Although if you're interested, maybe we can talk about it in the Q&A. You can do concurrent raises, so maybe you can do $1 million here, and at the same time maybe do a 506B and raise more money there. So we can talk about that. The bad news is, and this is really where I think this kind of falls apart a little bit. So even though you can take non-accrediteds, the limitations are even stricter than the Reg A Plus we just talked about. So you are limited if they have, it's actually, I don't want to get too complicated, but it depends on whether they have a net worth or income of $100,000. And so you can only take 10% of their income or their net worth, whichever is lowest. Okay, so if you've got somebody who's worth 200 grand, but they're only making $60,000 a year, you're going to be limited to $6,000. And I think if you go all the way down, the minimum is 2%. So you can do 2% of their income or asset or their net worth, or this limitation of 10%. So that's one kind of killer. And then if you're also limited to a $100,000 investment per 12 months. So that's another kind of a limitation. And then the last thing is they, what am I thinking? 10%. The last thing is you've got some compliance too. So they're not as harsh as the Reg A Plus, but you still have to give some reports, audited financials, and there's also some reporting on your end. So if you're the issuer personally, depending on how much you're raising, anything over 500,000, for example, you're going to have to give audited financials of your company. If you're doing between 100 and 250, you've got to give certified financials. And if it's under 100,000, then you can do your financials just certified by your CFO. But there's that compliance. So there's a compliance not only on your end, on the front end, but also there's compliance, ongoing compliance on annual and semi-annual filings. So that's another negative. It does preempt state law, so that's a good one. But you also have all these fees, right? You've got to use this third-party portal that's going to do all the work for you. They're not going to do that for free. And I haven't looked up, in all honesty, maybe we'll do it at the Q&A, what the numbers were. But at the beginning, there were anywhere from 10 to 18% was going to go to that, to the cost. And that $1 million, by the way, is net, so if you're going to take all your fees off, they're going to come off that $1 million. So if you've got to pay the portal, it's going to come off of that. And then the other thing that's really scary in my mind is there's a rescission right. So the investor has up to 3 days after they put their money in to change their mind and back out. So somebody might put your money 2 days before your closing and then decide, hey, I want out, and suddenly you're short again. So not a huge fan of that. And so I'm going to talk about briefly one last one, which sometimes we use, but this is also a new rule. So let's talk about this really quickly. So the last one, again, I'm not sure how many of you are going to use it, but it's called Rule 147 and 147A. A is really the updated one. But these have to do with what we call an intrastate exemption, which essentially means you're doing a deal that's in your state, you're in that particular state, all your investors are in that state, and it's pretty much contained to that state. Then on the federal side, we might be able to rely on this Reg 147A, this intrastate exemption. And I'll draw it up, but it's really not that complicated. So number one, the original with A, you had to make sure that obviously your deal had to be in the state. So let's pick, let's pick Pennsylvania. So let's say your deal has to be in Pennsylvania. You had to be in Pennsylvania, so you have to be a Pennsylvania company, and you, as a sponsor, have to live in Pennsylvania. So you've got to live in Pennsylvania. I'm sorry, I don't know why I brought Pennsylvania, but you live in the state. And then finally, your investors need to be in the state. Investors in the state. And the reason this was dangerous is because you had to make sure you couldn't advertise or get that offering outside the borders of the state, which these days is very easy to do, right? If you send out an email to everyone, that email's bouncing around outside of the state. Maybe it's, who knows where the servers are going, or if you're putting something on Facebook or on your website, that's going to go to the public. So it was really a tough one. And then the other issue with the 147, sorry about that. The other issue with the 147, it does not preempt no preemption. So you have to go to that particular, so this is an easy exemption because we don't have to worry about the federal laws, but we do have to then go hire an attorney in that particular state to make sure we're following the state securities laws. I've had a couple of times where that's worked, where I picked up the phone and found, let's say, a Pennsylvania attorney, and they could do it really easy. They have pretty good securities laws. But most of the time, it's almost just as hard or just as expensive or just as whatever as doing a 506B or a 506C. So most people do that. The A came out recently again, and the only difference was they relaxed these laws a little bit. So the deal still needs to be in the state. Your company can be outside of the state as long as they have a principal place of business in the state. So maybe for asset protection purposes, you set it up in Delaware. As long as you register that in the state and that's your primary place of business, you could do that. And your investors, this is probably the biggest one, you could now expand your offering could be offered outside the state, but the sale had to happen only for in-state people. So even though you may have gotten out, as long as the investors themselves are inside the state, then you're good. And there's still no state preemption, so you still have to go to your state securities attorney, which may or may not work out in terms of cost. And again, maybe it's easier just to do a 506B, because now you're dealing with an expert. Again, 100% of my practice is syndication. You might go to a local SEC attorney where maybe only 25% of the practice is syndication. So I think that's it. I really appreciate you guys hanging in there. I know it's not the most exciting topic. Sorry for dropping my markers all over the place. So looking forward to the live Q&A that's going to be following, and happy to answer any questions you have. So with that, let's do the Q&A.